In California, if you've been married less than 5 years and you have no children, are of relatively modest means, and are not seeking spousal support, you may be able to get divorced by way of summary dissolution. Let's discuss the 8 factors that you'll have to consider in determining whether a summary dissolution is right for you. First, does California have jurisdiction to dissolve your marriage? In California, one of the parties, either you or your spouse, must have resided in the state for 6 months and in the county where you're filing the action for at least 3 months before the court can dissolve your marriage. Second, the court must have grounds to dissolve your marriage. The grounds in a summary dissolution are typically irreconcilable differences. Third, your marriage has to be considered a short-term marriage within the statute. That means it can be no longer than 5 years from the date of marriage until the date of separation. Keep in mind, date of separation does not necessarily mean the day that you get divorced. It's the day you and your spouse stopped living together as man and wife. No real property interest. In California, for there to be a summary dissolution, neither party can own real property or have any other interest in real property. There is an exception for short-term leases of a residence. Maximum debts. In California, for there to be a summary dissolution, neither party may have incurred more than $6,000 in debt during the marriage. Six, assets. In order to qualify for a summary dissolution in California, there must not be more than $43,000 in community property assets or $43,000 in separate property assets at the time of the summary dissolution. Please note, this number changes as time goes by and is adjusted according to the Consumer Price Index in California. So you need to be up to date and keep in mind that these numbers change. Number 7, spousal support. In order to get a summary dissolution in California, neither party can be seeking spousal support from the other. It requires a waiver of spousal support at all times going forward. Finally, in California, you need to remember, if you file for summary dissolution, the judgment will be final. There is no appeal and there is no right to a new trial. So in California, if you've been married less than 5 years, are of modest means, have no kids, and are not seeking spousal support, summary dissolution may be the right solution for you. Feel free to call us about any family law questions you have at CalDisso. The Judicial Council of California has put out a handbook for those that are seeking a summary dissolution. You'll find a link to that handbook in our description.